The next documents in your trust package are your pour-over wills. The pour-over will is simply an ordinary will that says you leave everything to your trust. Its main purpose is to act as another backup device that allows your trust to gain control of any stray assets left outside of your trust. In other words, if you happen to die with assets that are not titled in your trust and there's no other way to get to them, then the pour-over will can be used as a final resort to gain legal control over the assets. Problem is, any assets which must pass through a pour-over will are subject to the probate process, the very thing you're trying to avoid with a trust. That is why you should never let the existence of a pour-over will be viewed as a substitute for titling your assets in your trust. It's not. Your real goal is for the pour-over will to never be needed or have any use whatsoever. Most of the time, you can easily achieve that goal by titling your assets in the name of your trust, but even then, you still need a pour-over will as a safeguard against some unforeseen circumstance. To illustrate, we bring up the classic example of someone who buys a lottery ticket and is so excited to discover winning $1 million that they instantly die of a heart attack without ever having a chance to title the winnings in the trust. In such a case, the pour-over will could be brought into play as the only and last resort. Even though the law allows the use of small estate affidavits for probatable assets totaling under certain amounts, we suggest that you never view that as an invitation to leave assets outside of your trust. While the small estate process may be easier than full probate, it is still usually more troublesome and expensive than if the asset is titled in your trust. For example, in California, you must wait at least 40 days before you can use a small estate affidavit. In contrast, there is no waiting period with a trust. Your pour-over will automatically revokes and invalidates any previous wills, names your trust as the only beneficiary, and nominates your currently named successor trustees as your executors. The rest of the document consists of standard will clauses. Please sign and date your pour-over will, and also be sure to fill in the city in which it was signed. Unlike your other documents, your pour-over will should not be notarized. Again, do not notarize your pour-over will. Rather, it needs to be signed by 2 disinterested witnesses that are at least 18 years old. A disinterested witness is someone who will not benefit or inherit from your estate under any circumstances, directly or indirectly. In California and many states, your witnesses do not need to see you sign your will. You only need to state to them that you signed it. Make sure that both witnesses sign where indicated and print their name and address below their signature.